provide free legal services for survivors of sexual assault, rape, and human trafficking. And that includes representing them in criminal court as victims' rights attorneys, making sure that their rights are protected from prosecutors and judges who may have different opinions about how that case should go. We also work with victims on education issues if they're having issues in school after experiencing some kind of trauma, things in workplaces, making sure that their rights are protected when they're going back to work after experiencing harm, or within the workplace if they have experienced harm at the hands of a coworker or a supervisor. We also work on protective orders for survivors as well who are interested in being protected from folks that have harmed them. So I wanted to talk just briefly about a little bit why we supported this law. In talking about the past system, we had clients in our office who would experience harm, and the person that harmed them would immediately get bailed out, not because they weren't charged with a serious offense like a sex crime, but because they had the money to do so. And in a few of our cases, we had folks commit multiple sexual assault cases because they had the money to be able to bail out, not because a judge really looked at their case and said, this person has a past criminal history of sexual assault, this person has significant evidence against them, we believe they are a risk to the community or could cause further harm, and we are going to detain that person. They didn't do that. They just gave them a high enough bond and said, well, I bet this person can't pay $250,000. Well, in some cases they could, and it meant that that person got out. So for us, this was a very clear issue of not only racial justice and issues related to poverty and how are we thinking about crime in a holistic way, and also for clients in real time who were experiencing harm from the bail system in particular. But I do want to talk just briefly. Ben gave a really great overview about how the law works in practice, just broadly speaking. But we did tinker with some of the specifics around the victim rights law here in Illinois to make it even better for survivors. Even though we think the system is already better, just from the perspective of getting rid of money bond, and really having to hold prosecutors and judges accountable for the decisions that they're making about victims' cases. So for us, we think that this is already a better system. And we made a point to change other parts of the law to make it even better. So one of the things that I know we had talked about earlier in one of your examples is improved notification requirements. Before the law, victims didn't get notification of bond hearings. Usually bond hearings happen really quickly, right? They take 30 seconds to 2 minutes. There was never time in that process to call the victim and ask them, what do you want to happen with this case? Do you even want a case to move forward? We have some clients in our office who don't necessarily want a case to move forward. They called police in order to stop kind of that violence the moment it was happening, but not necessarily to continue on in working with law enforcement on building a case. So we made sure that that was put back into the law, that bond hearings were no longer exempt. We now call them initial appearance hearings, but that was the problem before. They weren't getting notified of those hearings. So now that's back in there saying you have a right to be notified of that initial hearing and every other court hearing pertaining to your case afterwards. The other thing we did is we made very clear, when Ben was talking about kind of the criteria in which someone could be jailed pre-trial, you talk about a real and present threat to a person or the community. We made sure that it's very kind of legalese, but to define real and present threat, including the definition of abuse in the Illinois Domestic Violence Act, to make sure that domestic violence cases were really fully accounted for when prosecutors and judges are making these decisions about what is a threat to someone. So anything that would qualify as domestic violence under Illinois law would count as that real and present threat. And like Ben had said, domestic battery, both at a misdemeanor level and a felony level, are considered detainable offenses. The other changes that we made is we require prosecutors to notify victims of their ability to get a protective order at the point of the initial hearing, the detention hearing, if the prosecutors decide that they would like to detain someone and present that argument to the judge, and any other future court proceedings. So this doesn't change their ability to get a protective order. We've always had that under Illinois law with the order of protection for domestic violence, the civil no contact order for sexual assault, or the stalking no contact order, which is somewhat self-explanatory. Those have always existed, but now prosecutors are required to tell victims when they notify victims of these hearings to say, yes, here's the information around the hearing, and oh, by the way, you have the right to ask for a protective order from that judge pertaining to this particular case. So that's kind of an additional thing that victims have at their disposal to be able to navigate the system and help them create safety for themselves.
Could you describe a protective order?
Sure. It's like a restraining order. I mean, we call it a protective order in Illinois law, but it's really like a restraining order. And the way that you can file a petition for one is you kind of specify, do you want this person to stay away from your home or your school? Do you want to make sure that kind of exchanges around children are negotiated? So you can kind of set out, it's a very individualized process, so it's hard for me to describe exactly what it looks like, because for every victim, they can specify what remedies, that's what we call them, what remedies they want under the law to, again, ensure what safety looks like for them.
So April's example of somebody breaking into her car or into her house repeatedly, she could ask for a protective order.
So we have three types of protective orders in Illinois. One specific to domestic violence, and you have to kind of be a family member or a dating partner in order to qualify. For a civil no contact order, it's for cases of sexual assault. What we found about 15, 20 years ago was that sexual assault victims were trying to get protective orders through the Illinois domestic violence law, and they didn't really qualify because it was a different type of violence. And then we have our stalking no contact order. So I think potentially, yeah. The other thing though is as part of the conditions of someone being released or conditions of someone being detained as well, they would have like a no contact directive from the court. So the court would still say whether you're released or not, you are not allowed to have contact with the victim. And then kind of the remedies and the process of how that is enforced is through the judge pertaining to that case. You can also get a separate protective order for those kinds of additional cases.
So in April's case, break-in car, break-in.
Sure.
Can she get a remedy of some kind?
You could probably be eligible for a no contact directive as part of a person's conditions set on them for pretrial release, or a condition of them also being detained. Most often, even if someone is detained, there's usually some kind of provision from the judge saying you are not allowed to have contact with the victim for the duration of the case.
How easy is it to get that kind of thing, or difficult?
For a no contact directive for someone's individual case, relatively easy. For a protective order, it usually goes to a hearing, either an emergency hearing, depending on kind of the timeline of the case, or a hearing later on.
So that, it sounds like.
But it takes time for it to be processed, right?
It does, it does.
That's time to come back.
Right, in the meanwhile.
Yes, I mean, that's one of the things that we struggle with in terms of, to me, I always say it's not necessarily the law that's the problem. It's police officers, sheriff, deputies, or prosecutors or judges doing their jobs in the way that they're supposed to. One of the struggles that we see, exactly to your point around protective orders, is even when a victim has a protective order ready to go, it's been approved by a judge, it can take 24 to 48 hours digitally to be inputted into the sheriff's system. So you're right, there is absolutely a lag, and it's one of the things that we continue to work on. But the law is not necessarily the problem. It's our technology, it's our budget, our staffing, our resources, all of that is super important. So,
Well, I don't understand something.
yeah.
So if the judge issues a protective order, and the same day the person comes back, but the person would know.
Sure,
So
so,
wouldn't that person be penalized?
yes.
Consequently of violating the protective order?
Yes, so specific, there's a no contact directive, which is kind of the lower level one for kind of any case involving a victim. And then we have our three types of protective orders for those kind of stalking, domestic violence, and sexual assault cases. If someone violates one of those protective orders for domestic violence, sexual assault, or stalking, that is something that prosecutors are required to file a detention petition on. For those specific, because we kind of understood when we were drafting this and kind of our broader coalition that domestic violence in particular can be so dangerous that really we're kind of eliminating the discretion that prosecutors have by saying this person had an order of protection, they violated it, now they're back in court. You don't have the option to say, you know what, we don't really want to detain this person. The judge is still going to make the call, but the prosecutor has to file that petition, that documentation to the judge and make the argument that this person should be detained. So for violations of those orders of protection, which is specific to domestic violence, for one's for sexual assault and one's for stalking, they have to do that. It was one of the kind of key things that we really wanted in this law, was making sure again that we are holding prosecutors and judges accountable for their decisions, because oftentimes in our clients we would see a sexual assault case charged and then they would say, oh, they got a $100,000 bond, thinking that maybe a person could or couldn't afford it. But they weren't really holistically looking at this case, understanding maybe the defendant's wealth or not, They weren't listening to our client about whether they felt safe or not with this person out. They were just looking at the charge, a person's criminal history, and applying racism, sexism, all of our systemic forms of discrimination, and saying, this is what we'll do. And it was a really quick and not individualized process. I also want to note though, one of the things that we changed, I know that there's a lot of problems with risk assessments, exactly what Ben outlined, but one of the prohibitions before we changed the law was that victims weren't allowed to participate in risk assessment interviews. So again, it was intended to be this very scientific, neutral process, right? But it ended up becoming incredibly racist from all of the reasons that Ben outlined, and really not providing any good information to the judge and the prosecutor about how to make these decisions. And victims were prohibited from giving their input to contribute to the risk assessment, which is wild considering victims and survivors probably know what safety looks like for them, and they probably understand what would make them feel safe or not. So they weren't allowed to participate before, now they are, under this new law. They are allowed to participate in those interviews. It's up to a person whether they choose to or not. It's not a requirement that a victim participates. It's simply another way of being able to participate if they want to. There's also kind of an enhanced and more limited process for the defense calling victims as witnesses at detention hearings. This is extremely limited in terms of how often this happens, so I don't want to spend a ton of time on it, because in our cases, we have not had a case where a victim has been called to the stand in those early kind of preliminary hearings before trial. We have not had that happen, and we've been around for a really long time. So it's not that it doesn't happen, but it's not something that happens super commonly. And before, it just had the option of the judge being able to decide whether or not it was appropriate for the victim to do so. There were really no limitations. Now the judge has to hear an argument from the defense that the defendant would be materially prejudiced, is the language, that the defendant would be so severely impacted in their case if this victim did not testify. So it's a much more limited process, whereas before it was just kind of open. So those are the few things that I wanted to mention about kind of the victims' rights cases. But like I said, it's something that we supported along with a lot of other domestic violence and anti-sexual assault agencies. We take on a wide variety of different cases, cards, business card brochures. I'm also happy to take questions, but I just want to get through some of those victims' rights stuff.
No, that was very good information, though. Very good information.
Yeah. I understand the skepticism. I mean, one of the big things that we kept hearing is like, why do you guys support this? This doesn't make any sense, because the misinformation had gotten so out of control. But we really feel incredibly strongly with how our clients are being treated now in this new system. We still have a long ways to go in terms of resources and staffing and that implementation work to make sure that prosecutors and judges are doing their jobs.
Right.
But the law, we really believe in. We really believe that this is going to be Pretrial Fairness Act, yes, which encompassed all of these changes. I mean, it was like a 700-page bill. It was an incredibly long process to get there. But we really know that this is going to be a better opportunity for victims to not only be heard in this system, but to be protected, because they get to define what safety looks like for them, rather than leaving that entirely to prosecutors and judges who are just filing all the paperwork.
So what is, okay, so because all of this is a part of the umbrella of the Safety Act,
Yes.
right? So who should we talk to in terms of trying to get a better handle on everything that the Safety Act brought? Because, I mean, when it was coming down, I was trying to get in contact with some folks that may have an idea, but a lot of the things, a lot of folks didn't have real information for it because things weren't in place. And now that they are in place now, who's the best contact so that we can start to educate the community around with it?
I would actually point to Ben and Josh. I mean,
Oh, okay.
CLU has done a ton of work, not just on the pretrial fairness, the end of money bond, but also
Right.
the law enforcement training that's required, the law enforcement certification, the other parts of the Safety Act.
Okay.
So,
Yeah, I think that's important, dispelling the myths of the Safety Act itself, because that was one of the things outside of pretrial fairness that in and of itself was something that folks were really staunchly afraid of because they didn't know what it was.